Welcome back. This lesson is the third and final part of our short series on distributions from your estate. In the first lesson, you focused on who should receive something. In the second, you explored how distributions can be structured. Today, we're focusing on timing and contingencies, when distributions happen, and what happens if something doesn't go as planned. In this lesson, you'll take 3 simple actions. You'll decide whether distributions should happen right away or later. You'll think through a few common what-if moments that many people overlook. And you'll understand why planning for things that might fall through the cracks using a residuary clause is one of the most responsible steps you can take. Let's start with the when, the timing of your distributions. Most people think of a will as a simple handoff that happens all at once. This is an immediate distribution. Once the court process is complete and the bills are paid, your heirs receive their inheritance with no strings attached. It is straightforward and brings a quick conclusion to the estate. An immediate distribution like this may make sense for a capable adult who is ready to manage it. However, you might be concerned with a younger beneficiary receiving a large amount of money all at once, or maybe you're worried that the adult beneficiary has creditors who will receive your gift instead. In these situations, you have a few options, but most of them include the use of another estate planning tool called a trust. Trusts will be covered in more detail in our next unit. For now, know that trusts provide added flexibility in determining if your beneficiary should have delayed distributions, or even if you would like to stage the distributions over time. For example, a portion of the inheritance is received when they reach age 25, another portion at age 30, and the final balance at 40. This allows your heirs to grow in their financial maturity while still having a safety net in place. It is important to clarify at this point that a will acts as a transfer document which tells the court who the new owner of property should be. That process aims to finish and close, not stay open for decades. This is why staged timing of distributions frequently connects to a trust, often a testamentary trust, which is a trust that can be created at death through a will. On a related point, in many places, a minor typically can't receive certain assets outright the way an adult can. That's one reason tools like the Uniform Transfers to Minors Act, also called the UTMA, exist. These state laws create a framework where an adult manages property for a minor until a set age. The details vary by state, but the big takeaway is simple. If you want a clean, intentional plan for minors to receive funds, you usually want a plan that describes the details for who manages the funds and how. Beyond timing, you might also consider conditional distributions. These are gifts that only happen if a certain event occurs first. For example, you might say, "My daughter-in-law receives this gift only if she is still married to my son." While there may be many reasons you would want to put a condition on a gift, they come with a pause and check warning. Courts generally will not enforce conditions that are against public policy or are too difficult for an executor to monitor. If a condition is too vague, like requiring someone to live a virtuous life, it may fail because a judge can't clearly define what that means. Now, let's talk about what happens when things don't go as you planned. Life is dynamic, and sometimes a plan that looks perfect on paper encounters a reality it didn't expect. There are 3 common ways a gift can fail to go to the person you expected. The first is when a gift lapses, the second is when a beneficiary disclaims the gift, and finally, if the gift you intended to give is no longer in your estate. The first scenario is a lapsed gift. This happens when a beneficiary you've named passes away before you do. If your will is silent on what happens next, that gift lapses or fails and may need to be distributed according to the laws of intestacy if you did not provide for a backup plan. We touched on this earlier when we discussed residuary clauses in an earlier lesson. There's also the possibility of a disclaimer. Believe it or not, a beneficiary can actually refuse a gift. They might do this for tax reasons or because they feel the asset should go to someone else. If someone refuses a gift and you haven't named an alternate, the law treats it as if that person had died before you, and the gift falls into the leftover pile, similar to the situation above. This is why we continue to talk about the residuary clause. If you remember nothing else from today, remember this. Your residuary clause is the ultimate safety net for your legacy. It is the catch-all instruction that says who receives everything else: the assets you forgot to list, the property you acquired after signing your will, and any gifts that failed because of a lapse or a disclaimer. There's one other legal tool that is often used in wills to deal with these situations, and it's the use of specific legal terminology, per stirpes and per capita. These phrases are used in describing the distribution to a person and describe how a share is redistributed if a beneficiary dies before receiving it. Per stirpes means the share follows the family line. If a child dies, their portion may pass to their children instead. Per capita means the share is redivided among surviving beneficiaries, so everyone still living receives an equal portion. For an illustration of how this might look, please see the resource section. Finally, the third scenario is when the gift can't be delivered because the thing isn't there or it's tied up in a way you didn't expect. Even if you wrote the gift down perfectly, real life can change what's actually available. Here's the perspective shift for today. If your will doesn't answer what if, the court will need to. By being explicit and planning for the what ifs, you decide what will happen. One example solution in the case of a beneficiary not taking a gift you intended is to set up a backup person, often called a contingent beneficiary. It's just a simple Plan B, and adding that Plan B can be necessary to ensure your intentions stay intact. One more quick note that matters. Avoid making assumptions that everyone will be there or that everyone will agree. Instead, assume that change is possible and build a plan that is strong enough to handle it. So, what is next? By watching this video, you have already moved past the hurdle of assuming everything will go perfectly. You now understand that a responsible plan is one that accounts for detours. In our next lessons, we will discuss probate and the laws that govern a will. We will discuss how to review your documents and how to finalize them so they can be used to put your plan into action. If you're ready for a small immediate step for your top 3 gifts, just ask yourself, if this person isn't there, who is the second choice? Write that name down. You've just created a backup plan. For those who want to go deeper, we have optional resources in the resource section to learn about transfers to minors, checklists for planning distributions, and state laws that may impact your estate. They will help you walk through the what-if scenarios we discussed today so you can ensure your instructions are airtight and your legacy is protected, no matter what surprises the future may hold.